discuss the important things in parole system. Presidential Decree 1257 is a participation of the prosecutor in the determination of the application for probation. Presidential Decree 76 is the period of punishment which is probationable is extended from 6 years and 1 day. While in Presidential Decree 1990, the period of punishment which is probationable is lowered again from 6 years and 1 day to 6 years or less. As you can see, the PD 76, the period of punishment is extended from 6 years and 1 day, while in PD 1990, the period of punishment is lowered again from 6 years and 1 day to 6 years or less. EO 292, or it is called Administrative Code of 1987, renamed the Probation Administration into Parole and Probation Administration. Nature of information gathered is strictly confidential and privileged. So, ang mga information ay secured and confidential. Nature of post-sentence investigation. It is recommendatory in the nature and addressed to the sound discretion of the trial court. So let's proceed in effectivity of probation. It is upon its issuance. If the application of probation is already issued. Finality. The order of the court granting or denying probation shall not be appealable. It means it is the decision of court if they will grant or deny the application. Petitioner is an accused or defendant who files a formal petition for probation. Next is absconding petitioner, a convicted defendant whose application for probation has been given due course by the court but fails to report to the probation office or cannot be located within a reasonable period of time. Probationer is a person placed on probation. Absconding probationer. Ito naman yung person na na-grant na yung kanyang application of probation pero failed to report for supervision or fails to continue reporting for supervision or whose whereabouts are unknown for a reasonable period of time. Probation officer is the officer who investigate for the court a referral for probation or one who supervise a probationer or both. Parole is to refer to the conditional release of an offender from a penal institution after he served the minimum period of his prison. Next is parolee, refer to the person who is released on parole. And pardonee is referred to a person who is released on conditional pardon. And client is referred to a pardonee or parolee who is placed on supervision. Next, board is refers to the Board of Pardons and Parole. Administration is refers to the Parole and Probation Administration. And the director is refers to the director of the Bureau of Corrections or BUCOR. And the administrator is referred to the administrator of Parole and Probation Administration. Okay, let's move in history of parole system in the Philippines. It came into existence by the passage of Act 4103 as amended by Acts 4203 and 4225 or tinatawag na Indeterminate Sentence Law which took effect on December 5, 1933. Next is the Board of Pardons and Parole. It is the administers the parole system of the country. Next is the pre-parole investigation. The administration has been authorized by the board to conduct pre-parole investigation of the serving city, provincial, and national prisoner confined in the city and provincial jails, the national penitentiary and penal colonies, whenever their best interest and that of justice will be served thereby, and to submit reports of said investigation at least 50 days before the expiration of the minimum sentence of the prisoners concerned. So these are the prisoner qualified for parole. Unless otherwise disqualified under Section 15 of the rules, a prisoner shall be eligible for the grant of parole upon showing that A. He is confined in a jail or prison to serve an indeterminate prison sentence, the maximum period of which exceeds 1 year, pursuant to a final judgment of conviction, and that he has served the minimum period of said sentence less the good conduct time allowance, or GCTA, earned. There is a reasonable probability that if released, he will be law-abiding, and that his release will not be incompatible with the interests and welfare of society. So this is the prisoners disqualified for parole. 1. Those persons convicted of offenses punished with reclusion perpetua. Next is those convicted of treason, conspiracy, or proposal to commit treason. 3. Is those convicted of misprision of treason, rebellion, sedition, or espionage. And number 4 is those convicted of piracy. 5. Those who are habitual delinquents. 6. Those who escape from confinement or those who evaded sentence. 7. Is those who were granted conditional pardon and violated any terms thereof. 8. Those whose maximum term of imprisonment does not exceed 1 year or with a definite sentence. 9. Those suffering from any mental disorder as certified by a psychiatric report of the Bureau of Correction or National Center for Mental Health. 10. Those whose conviction is on appeal. 11. Those who have pending criminal case for an offense committed while serving sentence. And let's proceed on composition of the boards of pardon and parole. The chairman is the secretary of the DOJ. The ex officio are those probation administrator of the parole and probation administration. Members is the sociologist, clergyman or educator, psychiatrist, and D. person qualified for the work by training or experience and a member of Philippine Bar.